charging and elements of a crime. In this section, we'll be continuing to look at the stages of pretrial and how charging and elements of a crime factor into pretrial process. We'll be looking specifically at the charging documents and the different ways that we can charge for criminal activity. This is a summary of the pretrial process. And as you can see, our discussion box for charging is along the side, and that's only because we visit and revisit the concept of charging throughout the pretrial process. So it's not really near the end or near the middle or near the beginning. It is something that we address and evaluate and reassess throughout the pretrial process. Just a very quick primer on elements of a crime so that we can be thinking about the elements of a crime as we move on through pretrial and trial. When a statute is written, it's written formulaically in that it has these same parts in every statute. Those parts are mens rea, which represent the mental state, actus reus, which represents the actions, and together those things make up the body of the crime or the corpus delicti. So the mens rea is all about the mental state required by the statute. The statute will specifically say what you need to be thinking at the time of the crime in order to commit the crime. And then, of course, the actions, what you actually need to do in order to have committed the crime. Together, again, those things represent what makes up the crime. Now, just side note, corpus delicti, even though it technically translates to the body of the crime, has nothing to do with an actual body. So if we're dealing with a homicide crime, the fact that the entire statute is called the body of the crime really has nothing to do with whether or not a body is here or there. I see that a lot. Body of the crime in the context of statutory elements has nothing to do with an actual body. When you see a crime written, you'll see it written with these mental states built in: knowingly, intentionally, purposefully, negligently, recklessly, and then of course the actions. A person intentionally does some things to commit a crime, or a person recklessly does some things, the actions, in order to commit the crime. You'll see this same formula followed as statutes are written. This is an example of how an Oregon assault statute looks. So we have the text of the statute up top, and then we have just a demonstration of how it breaks down into that formula. So Part A, for example, a person commits the crime of assault in the second degree if the person, and then Part A, intentionally or knowingly causes serious physical injury to another. So you'll see down at the bottom under Part A, we have intentionally or knowingly as the mental state, and what do you have to do? You have to cause serious physical injury to another. So if we were going to charge for assault in the second degree, 1A, we would have to document or demonstrate or somehow prove that the person intentionally caused serious physical injury to another or knowingly caused serious physical injury to another. And then Part B are other options for charging, and Part C are further additional options for charging. So when an officer responds to a crime in order to make an arrest, they do their investigation, they develop their probable cause, and when you are developing probable cause, you are working towards those elements of a crime. Ultimately, you have to prove that the person did the mental state and the actions that are required by the statute. We can't arrest somebody for assault in the second degree unless we can show that they intentionally caused serious physical injury. So we do that by gathering all the facts that show that they did something intentionally. What are all the information, the witnesses, how they sounded, what they look like that show intention? And then how do we prove that they caused a serious physical injury? Well, we get the medical reports, we take pictures of the wounds, we do all these things to prove that there was the intention and that they caused the serious physical injury. When we have enough and we have reached the ability to establish that that mental state and those actions were met, we have probable cause for an arrest. An officer establishes and writes that probable cause on a charging document called a complaint. Those are supported by an oath or an affirmation by the victim or the arresting officer, the victim saying, this is what I'm testifying to, and the arresting officer saying, this is what I've gathered, and this is what I affirm to know as the truth and what I am basing my arrest on. That happens on a complaint document. Now, envision a piece of paper that has the word complaint written across the top. You have to be able to articulate all the elements of the crime. You have to be able to articulate the mens rea, you have to be able to articulate the actus reus, and show that the mental state and actions were present in that particular situation or scenario. If you erase the word complaint at the top of that paper and write the word information, this is still a charging document. It still requires the same type of information, except the information document comes from a prosecutor. So if an officer makes an arrest for assault in the second degree and it shows up on the prosecutor's office the next desk the next day, and the prosecutor looks at it and says, well, yes, the officer had enough for assault in the second degree, but I think he could have also charged something else, or I think he should have charged maybe assault in the first degree would be more appropriate, or assault in the third degree is more appropriate. The prosecutor takes a piece of paper, the information, writes out the same stuff, mental state, actions based on the police report, based on video, based on the evidence that came along with the report, based on their own investigators that they send out into the field to go do additional fact-finding. When the prosecutor is ready to charge, wants to change a charge, update, mitigate it, aggravate it, they fill out a charging document. That document is called information. Again, it serves the same purpose as a complaint, looks very similar to a complaint, has very similar information as a complaint. We just call it information. Now, a judge, on the other hand, does an arrest warrant. Again, same concept. We have to be able to establish that an offense was done, that somebody broke the law. In most cases, and the one that we're most familiar with, that's not showing up to court, that you have failed to do what you were supposed to do, and so they fill out an arrest warrant. That arrest warrant has a charge on it that says failure to appear. When you fail to appear, you intentionally avoid the trial process or whatever the language is. The judge has to do the same thing. They have to document the mental state, show that you did the actions, and they issue that arrest, that charging on a charging document called an arrest warrant. Technically, judges also have the power to put anything on that arrest warrant, not just the failure to appear. It could be any type of charge, although failure to appear is generally the most readily accepted type of arrest warrant that judges do. Finally, we have an indictment, which is just another type of charging document. When an officer makes an arrest and a defendant starts to go through the pretrial process, maybe the prosecutor looks at that complaint and says, yep, this is good, I don't need to make any changes, so no information is attached. And the judge is seeing you for your pretrial hearings and decides, I'm good with this, I don't need to add, you've been showing up, I don't need to issue an arrest warrant. The complaint is just making its way down the pretrial process. When that particular arrest is heard by a grand jury, the grand jury is basically deciding, do we give a thumbs up to this charging document, or do we give a thumbs down to this charging document? If they give a thumbs up, basically all they're doing is saying, yes, we are going to sign the charging document confirming that the complaint is in good shape. We call that an indictment. It's just another charging document. It doesn't mean that you've been found guilty. It doesn't mean that you have somehow been actually sentenced to anything. An indictment is really just a grand jury agreeing with the charge or changing a charge, making up their own new indictment with new charges, aggravated or mitigated. If you get an indictment, it just means the grand jury is agreeing or establishing that charges should be made. If there is no charges, then no indictment is issued, and we have a process for doing that, which we'll look at later on. So at this point, when you look at charging documents, remember that charging documents, the complaint, the information, the arrest warrant, and the indictment, that's really all they are just documents that show the charges and have the information that builds and substantiates that those charges were based on probable cause. If there is mental state and actions required by the statute, which inevitably they are, on the charging document, you will see the articulation that says, I am charging a person with this crime, here's the mental state, here's the actions, here are all the facts that support that charge. We are going to charge this person with this crime. Charging documents. This is a sample complaint just to give you an idea of what a complaint looks like. So at the top you see obviously complaint, and then down below you see information. So we have that this happened in the state of New Jersey. We have the defendant's information. We have a short little paragraph that gives some details about what happened in this particular incident. Usually you will see, see digital record, or there'll be a much bigger narrative section that has more explanation of the full context of the arrest, but this particular complaint just has a short description. You can see where there's listed charges. Down at the bottom, it is certified and signed by the person who is filling out this complaint. And then down at the bottom, obviously, you see a date to appear. And as we discussed when we talked about arrest, remember that there's an in-custody arrest and there is a non-custodial arrest. This is basically where a person would sign. They are promising to appear for their first pretrial hearing. They either sign the bottom of this citation if it's a non-custodial arrest, or this document is provided to corrections in order for them to show up and make sure that the person, help the person to show up for their first appearance. And again, a continuation of this complaint. This is a second charge that's been added. And again, you can see a little bit more information in the narrative section with the charge, and again, the certification and the date to appear down at the bottom. So when it comes to charging, we do have various documents that we can provide charging information on. The complaint, again, comes from the officer, and this is the one that we think about all the time. Officers respond to calls, they do their investigation, they write out the charging document. That's on a complaint. We think about officers in charging and making arrests readily. That's one that we see all the time. What we don't see so much of are the other versions, which is information, arrest warrants, and the indictments. Yes, we hear so-and-so's been indicted. We hear that in the news. We hear about indictments all the time. We hear about arrest warrants being issued. We don't hear much about information, which is sort of odd because prosecutors actually have the most power when it comes to charging. After an officer makes an arrest, those charging documents are always given to the local prosecutor for them to review. It's for them to review, it's for them to decide if they want to continue on with the charges. When an arrest is made, those arrests are basically given to the prosecutor for review. The prosecutor then has total discretion in deciding what to do with those charges. Do I say the charges are good to go and put my signature on an information sheet that basically says these are the charges, I agree, here they are, I'm going to write it out on my little information sheet, I'm going to sign it, good to go, continue moving forward? Are they going to aggravate the charges? Yes, I see the police officer wrote this report, but I think we could move ahead with a higher charge or something more serious. Do we mitigate them? Yes, the officer arrested for assault in the first degree, but I think assault in the third degree would be more appropriate. So I am going to fill out an information with assault in the third degree. That prosecutor gets the ultimate discretionary ability to decide what to do with those charges. Continue them on with a signature and a thumbs up, aggravate them, mitigate them. Prosecutors can even toss charges out completely. Prosecutors have complete control over the charging process. They are the gatekeepers to the charging process. Officers can make arrests until they're blue in the face. Ultimately, the prosecutor gets to decide whether or not those charges move forward. An officer may make a charge, and if it's dismissed, it doesn't necessarily mean that the charge was bad. It might be that the documentation is not good enough. It might be that they're building a bigger and stronger case against someone. So rather than arrest them for burglary tools, we're going to hold on to this and continue adding it to that person's file because eventually we want to get them for a burglary syndicate or something much bigger. It might be that the prosecutor is in the midst of prosecuting 10 homicides, and this tiny little burglary tools case is not something that they want to deal with right now. I'm going to toss this charge. It's their first offense, whatever the case may be. The tossing of a charge doesn't necessarily mean misconduct. It can be done for a lot of reasons, but ultimately, and the more important thing to think about, is that prosecutors have total discretion in deciding whether or not an arrest and that charging document can stand as it is, and whether or not we continue with pretrial. And I have a little video to show you some more information on this.
Of all the actors in the criminal justice system, no actor makes more decisions or a wider array of decisions than the prosecutor. The police decide, do we arrest this person or not? And judges basically face the question of how much we sentence this person convicted of to prison or not. But prosecutors have to decide, do we charge at all?
In my mind, behaviors have become criminalized in a lot of different ways.
We criminalize basically everything. Throughout the 70s, 80s, and 90s, our lawmakers were driven by politics and fear to think about criminalization in the criminal justice system as the answer to all of societal ills. We know that didn't work. We're seeing the results of it today.
District attorney can go to a police department and say, look, I have no interest in prosecuting marijuana offenses or prosecuting name your offense. They can do that.
And the idea of being able to drop charges or downgrade charges, that's consistent with what they're ethically obligated to do. But unfortunately, we seem very often to see it being used much more to win.
We don't see many prosecutors throwing pizza parties or sending out emails praising the work of a prosecutor who dropped a charge, even though that has, in some ways, an even more important and bigger effect on a citizen's life.
We don't have to wait for laws to get changed. We don't have to change the way that the police are behaving. We don't have to make the private prisons happy just by changing our decisions. And by measuring the outcomes of those decisions, we could change the criminal justice system tomorrow.